So just how do motor vehicle accident lawsuits work? Well, if you watch enough personal injury lawyer commercials, you probably think it works like this. I call a lawyer and I get a check. Well, in a way that's true. They just sort of don't tell you everything that happens in between the phone call and the check in the 15 or 30-minute spot or on the side of a bus. So what I'm going to do here today is break down just an overview of how the litigation actually works in a personal injury case. Now, I'm in Nevada, and it is not exactly the same in every single state. It's especially different in PIP states, but overall, this is kind of how it works. A motor vehicle accident happens, somebody is injured, the injured party has medical bills, lost work, a damaged car, things like that. So what are they going to do? Well, you want to bring a claim against the party that caused your injuries. Well, how does that work? Well, if you've got a small claim with small damages, you may want to do it yourself rather than hire a lawyer. If you have a larger claim, you definitely want to go get a lawyer because of what is involved and potentially the value of your claim. So what does it mean if you go get a lawyer? Well, personal injury lawyers work on what's called a contingency fee. What that means is instead of charging you $2 or $3 or $500 an hour to bring your lawsuit, what they do is they say, okay, injured person, here's what I'm going to do for you. Instead of you writing me a check for every hour I work, I'm going to charge you nothing. I'm going to front the court costs. And then at the end, when we win, hopefully, I'm going to take my percentage out of the settlement or the verdict. And those vary widely. Sort of a ballpark standard is about a third. So theoretically, if you had a $100,000 case, the lawyer would take a third of that, or $33,000 and change. And then whatever costs like filing fees, process server, things like that, those would also be taken out, and then you would get the rest. And if you have a half-decent lawyer, your lawyer's never going to take more than you get. Unfortunately, there's certain circumstances where you'll see a lawyer's going to get a big chunk of it, and by the time everything's deducted, the injured person's going to get a very small piece, and that's just not cool. Anyway, so this video is about how these lawsuits work, not how lawyers work, but I just wanted to give you that up front. So if you've never been through this before, you know a little bit of what to expect when you talk to a lawyer. All right, so here we go. So the accident happens. You want to bring a claim against the person that caused the accident, caused the injuries. So what do? Well, the first thing you do is you gather your evidence. You're going to need two different kinds of evidence. You're going to need evidence that shows liability, that the other person was at fault, and then you're going to need evidence that shows damages, which means you were injured, lost work, medical bills, things like that. So in order to show liability or to show that the other person is at fault, collect things like a police report, take pictures of the scene. You definitely want to get the license and insurance information from the person that caused the accident. If there's witnesses around, you certainly want to get those witnesses if you can. Now, obviously, if you're incapacitated, the most important thing is to get yourself to a hospital and get treated. But if you do have the ability to collect evidence about the accident scene, definitely do that. And so that information is necessary because it's given to the claims adjuster who works for the insurance company who insures the driver that caused the accident. And that information they use to show, oh, look, the person we insure is at fault. So because we insure them, we're going to have to write a check. And so once they know the person they insure is at fault, based on the information we just talked about, then the second thing they need to know is what are your damages, meaning how big a check should we write. And the damages are based on a number of things. It's going to be based on your medical bills for the treatment you received as a result of the accident. Now, if you go to the hospital because you have a broken leg after the accident, and then you go back the next day because you have COVID, well, presumably COVID wasn't caused by the accident, so that's not going to be covered. But your injuries related or the treatment related to your injuries from the accident would be covered. If you lost work, you're entitled to get your lost wages back. On the personal injury side, there's a number of things. Also, there's a property damage side. You can do that yourself or your lawyer can do that for you, but that's usually the damage to your vehicle. So you definitely want to get that resolved too. You also are entitled to get money for pain and suffering, and you're also entitled to get other things such as costs, and all of this can be broken down. But basically, you want to give the claims adjuster as much information as you can so they know how big a check to write you. Now, at the end of the day, if you've got $100,000 of damages, but the person that ran into you has only got a $25,000 policy, well, the insurance company is going to write you a check for $25,000 because that's the amount of insurance that was purchased by the other party. So then what? If you don't have enough, there's other things we can talk about in other videos, things like uninsured motorist on your own policy. Maybe there's other people that may be at fault, but that's something separate for a separate video. So in this case, you've given them the information they need to decide that the person they insure is liable, so they need to write a check. You've given them all the information they need to show how much the check could be. So presumably what's going to happen is they're going to evaluate the case, and they're going to come up with a range of what they feel the case is worth based on the documentation you gave them and based on what other cases that are similar settle for. And probably after that, they're going to make you a settlement offer. And so if the range is this is the low and this is the high, the settlement offer you get is going to be the low. They very rarely, if ever, start off with a high. So you should expect in your head when you get your first offer, it's probably going to be what you may see as a lowball offer. So don't be really excited to take it. The next step is to make a counter offer, and this is the negotiation process where you come to a number that the insurance company thinks is too high and you think is too low, but maybe it makes a good settlement or not. One of the important things about settling early on in a case like this is if you settle the case, you're going to have to sign a settlement agreement and a release that says you essentially dismiss all claims, known and unknown. So what this means to you is if you say, hey, look, I'm going to settle this now. I've had a week of treatment. I'm starting to feel better. I'll take that $5,000 check or whatever it is they're offering you. Then you sign it and everything's good. Well, next week you go to the doctor, you get an MRI done, and suddenly you've got a fractured vertebrae and you need a fusion and it's 6 figures. Well, you call up the insurance company and say, hey, look, you know what? This was missed. It's something new. So you need to pay me for this surgery and all the lost work I'm going to have and all the pain and suffering. And what's the insurance company going to tell you? No, you already signed a release. The release said you signed away your rights to all claims known and unknown. This may have been an unknown claim, but you've signed it away. Too bad, so sad. So don't be in a hurry to sign away your rights early on in a case for a low amount of money. Now, if your case doesn't settle early on, you're probably going to decide to file a lawsuit. And there's a certain amount of period of time that you may file the lawsuit. It's called the statute of limitations. Here in Nevada, it's 2 years from the date of the injury, the accident. So don't wait. If you wait 2 years and 1 day, no matter how bad your injuries are, your accident is gone because your accident is gone. Your claim is gone because you waited too long from the time of the accident to bring your claim. And unfortunately, this happens a lot, so don't let it happen to you. So let's say you decide you're going to bring your claim. You're going to do it within the statute of limitations. The way you start this is you file what's called a complaint. And a complaint is basically a legal document that says who you are, who the other person is, and what legal claims you have against them. You file that with a court. Once it's been filed with a court, then it needs to be served on the defendant, the person you were suing. And so most people will hire what's called a process server. The process server takes the complaint, they knock on the door, they say, congratulations, you've been served, and that begins the lawsuit. Now, once the person's been served, they usually have a certain amount of time, maybe it's 30 days, it depends on your jurisdiction, to file what's called an answer. And so when they file an answer, that basically denies the claims you made in your complaint, and it kicks off the time for the lawsuit. What's going to go on now is the complaint's been filed, the answer's been filed, so you enter something called discovery. Discovery is just a legal term for let's find out all the facts and witnesses and things like that in the lawsuit. So in these personal injury type lawsuits, what often happens at the beginning is each side will send written questions to each other. There are interrogatories, there are requests for admissions, there are requests for production of documents. Basically, it's questions that are put together by lawyers and sent to the other side. They're answered primarily by the lawyers with the help of their client to fill in all the gaps. So when you get your responses back from these written questions, you're going to get some information from them, but they're, of course, been sanitized by lawyers, so they're going to give you the minimum amount of information possible that still complies with the law. So other things that are going to happen too is experts are going to be hired, designated, whatever you want to call it. If you are the injured party, your experts may as well be your treating physicians and their reports, but sometimes there may be requirements for future medical care, so you may hire a separate expert doctor to say, hey, this is what the future medical care is going to be. You may want to get somebody else, an economics type person, to say, all right, look, medical care for the next 20 years is going to cost X amount of dollars per year, and there's going to be some great big total. If somebody can't work, you might get a vocational rehabilitation person. There's a number of possible experts you can bring depending on the facts of each case and the size of the case. Obviously, if you've got a $25,000 insurance policy you're fighting over, you don't want to spend $50,000 hiring experts because that just makes no economic sense. So when you are bringing a case, you're going to retain experts. The defense is often going to retain experts to rebut what your experts say. So at some point in the lawsuit, then there's going to be depositions. No matter how small the lawsuit is, usually the person that's injured is going to have their deposition taken, and then the person who's being sued is going to have their deposition taken. Now, if you've got witnesses, they'll also have their deposition. If you've got experts, they may be deposed as well as the other side's experts. And basically what a deposition is the parties, and when I say parties, I mean the person suing and the person being sued, are in a room with their lawyers. There's a court reporter, a stenographer who's basically taking down everything each side says. And the person taking the deposition is the lawyer asking questions of the other side. And then whoever's being deposed is simply answering those questions. And their lawyer may be raising objections during the deposition process, but it's rather informal. It's just in an office with the lawyers and a court reporter. There's no bailiff, there's no judge, there's nothing like that. And that is one of the things that's important to participate in. If you are bringing a lawsuit, you're going to have your deposition taken, and it may take a small amount of hours or a long amount of hours depending on what your case is all about. And like I said, the experts are probably going to be deposed too. And that's one of the key parts of the case, where not only are you going to find out what are some of the facts of the case, but you're also going to find out what's a jury going to think of everybody. If you're injured and you make a great witness, the other side is going to report to their insurance carrier, hey, look, this person who's injured, yeah, I think they were really injured, and they make a good witness, a jury is going to like them. What all lawyers know is generally juries that like people will give them money, and juries that don't like people generally will not give them money. So during your deposition, it's a time for the other side to see whether or not they believe a jury is going to like you. And if they do, then they have to know that a jury may give you money. So you've done the written questions, the depositions have been done. Another thing that may occur during the discovery process is there might be inspections. You may go look at a vehicle, or your attorneys or experts will. They may go look at where the accident happened, and just to try to get a better flavor of what caused this and what the injuries and the damages really look like. If you have a scratch on a bumper, a jury's going to look at that and go, oh, well, it's a scratch on the bumper. Maybe this person really was injured, maybe they weren't. But if you've got a massive crash and you've got huge property damage, maybe there's destruction of a pole, a house, or something alongside of it, those cases tend to be larger. Once the bulk of the discovery is done, it's fairly common for the people to get together and have a mediation. And a mediation is simply a process where the people try to come up with a number to settle the case. Post-COVID, a lot of times it's done by Zoom. A lot of times it's also done in person. You'll have a mediator, and it's just going to be in an office, and the mediator is going to go into one room where there's going to be the person suing with their lawyer, and then they're going to talk with them, and then they're going to go into the other room that's got the insurance company lawyer for the insurance company of the person being sued. And the mediator will go back and forth and tell each side why their case sucks and they should pay more or why they should accept less. And they do that to try to walk people to a rational settlement, or at least what they believe to be is a rational settlement. This is completely voluntary. If you hate what the other side's offering, you definitely don't have to take it. But many cases resolve through the mediation process. And one of the things that's positive about mediation is you are in control of the outcome. If you go in front of a jury, you never know what a jury is going to do. You can have the best case in the world and get a terrific result, or not get a terrific result, because juries throw in sort of this randomness that we don't have in our regular litigation. And so that's why people love mediations, and that's why so many cases actually resolve during mediation. Now, hypothetically, discovery is about done, the mediation's failed, what happens next? Well, motions get filed, and motions are basically their pleadings where each side writes out documents and they give it to the judge and say, hey, judge, this is why I'm right and the other person's wrong. The other side's going to oppose that and the judge is going to make a ruling. Oftentimes, this is about liability. It could be to keep certain evidence out. It could be to keep certain witnesses out. It could be to disqualify certain experts. There's a lot of things that happen when discovery is done, mediation fails, and a case is getting teed up for trial. Now, in some places, the judges are going to say, all right, if you guys are going to trial, we're sending you to a mandatory settlement conference, which is sort of like a mediation, but it's with a judge and it's court ordered. So you have to appear. This doesn't happen everywhere all the time, but it could. Now, the vast majority of cases settle before trial. However, if your case is going to go to trial, there's quite a few things to do. You, or probably your lawyers by this point, are going to work on jury instructions, and jury instructions are essentially providing the law that's going to be given to the jury to apply to the facts of your case to make their verdict. They're also going to prepare questions for voir dire. Voir dire is the jury selection process. So what happens is the judge will call in a bunch of jurors. The jurors get a bunch of questions asked of them, and they respond, and some jurors get kicked, some jurors stay until you impanel the jury that's going to hear the case. Then when the jury is going to hear the case, you have the lawyer for the injured party goes up first and provides an opening statement, describes a little bit about what the case is and what they expect to prove during the case. Then the other side gets to do their opening statement, and then the witnesses. So the witnesses get called. The plaintiff gets to put on their case first and call their witnesses. They'll do a direct exam. The other side's going to have an opportunity to cross-examine them. And so at the end of all the evidence being presented, each side does what's called a closing statement, trying to wrap it all up and say, hey, jury, based on all the facts here and based on the law that you're going to get in the jury instructions, you should find that my client is the correct person to win. All of this takes a lot of preparation, and this is the stuff the lawyers do. If you've never done this before and you want to handle it yourself, you definitely want to do a lot of research, because you don't want to get bogged down in screwing up some procedure that's going to lose your case for you. So at the end of trial, a jury is going to render a verdict. And if you are the winning side, you may want to file a motion to get costs and fees on top of your verdict. And if one side is particularly disgruntled, they have the ability to appeal based on errors of law or other issues that occurred during trial, and appeals will drag things out for much longer. And so this is one of the reasons people love to settle cases earlier, because this is a long and expensive process. It really doesn't make a lot of economic sense to do this for a small case, but sometimes it happens anyway. Of course, there are lots of details bringing a lawsuit that I didn't cover here in this brief overview, but at least this gives you a general idea of what happens when you do file a claim, and how it's actually going to take more than a few minutes between calling your lawyer, say, hey, I've been hurt, and getting that check.